frankly, for lack of a better phrase, all hell breaks loose. That's what happened here. And the intoxication is not an excuse or justification for it.
So a defendant's at a campground, goes a little nuts, brandishes a knife, physically harms a police officer, and he claims it was all because of some bad kratom. Okay, we'll run with that, but I'm not sure that Judge Prill will. So take a look at the sentencing hearing, listen to the defense's argument, listen to the prosecution's argument, and listen to how Judge Prill kind of picks it all apart. And then let me know what you think in the comments afterwards. My name is Dan. This beautiful kitten in front of me is Ellie. This is the Courtroom Files.
57332F. It's time to accept the sentences for his present represented by Attorney Timothy Turkelson. People are represented by Prosecuting Attorney Timothy J. Rukowski. Back on November 3rd of last year, the defendant entered no contest pleas to carrying a weapon with unlawful intent, resisting obstructing a police officer causing injury, 2 counts of resisting and obstructing, and indecent exposure. Ms. Karen Everland's prepared the pre-sentence report. It's dated December 2nd, 2025. In addition to the pre-sentence report, the court is in receipt of a sentencing memorandum that has been provided by Mr. Torkelson. Mr. Turkelson, I apologize. I don't know why I said that. I apologize. No problem, Judge. I've known Mr. Turkelson for years when he worked back in the county. We're against each other too, as a matter of fact, back in the day. Mr. Turkelson, I apologize again. So the court has reviewed the sentencing memorandum, and there is documentation that's been submitted to the court regarding guidelines, which we'll address in just a bit. But Mr. Turkelson, have you and your client had the opportunity to review the pre-sentence report?
We have done.
Are there any additions, deletions, corrections, or objections to the report other than guidelines?
Other than guidelines, there are none.
Sir, do you agree with that?
Yes, Your Honor.
Thank you. Mr. Rukowski, any objection to the report?
No objection to the report or the guidelines, Your Honor.
All right.
And the court had said that Mr. Torkelson, it's probably because his batting average was about the same as Torkelson from the Tigers.
Yeah, but when he hits, when he does connect, he goes deep, no doubt about it. Good one. Mr. Turkelson, let's begin with OV1.
Certainly, thank you. Judge, I laid out my objection in my pleading before the court, and I apologize. I didn't realize I was supposed to send this to probation as well. That was my fault, Judge.
Well, I'll take the responsibility on that because I've just started doing that. This plea was entered back on November 3rd, so I probably didn't mention it at the time, but I have been at least since January. At least I think I have. So okay. I'll take the hit on that.
Certainly, Judge, and I appreciate that. So, Judge, yes, I have 2 objections to the score. And the first is the aggravated use of weapon. I've laid out what the elements are that are required to be satisfied in order to prove the aggravated use of a weapon. And I would submit for the reason stated in my memorandum that this would be properly scored at 5 as opposed to what was scored at 15. And I say that, Judge, because there's no question that my client on this particular occasion possessed a knife. And there's no question he was under the influence at the time he possessed the knife. And his possession of the knife and his behavior that day caused concern for many of the people in the park. And as a result, they called the police and the police responded. I think what's significant, Judge, is that my client, I don't believe, necessarily used the knife in a way that would have threatened somebody, certainly said inappropriate things while in possession of the knife, made comments about harming people while in possession of the knife. But none of the witnesses said he pointed the knife at me, he tried to use the knife against me. They said he had it with him when he made those statements. I think also significantly, Judge, the prosecutor's office hasn't charged felonious assault under these circumstances. And I think if there was enough evidence to believe, in fact, he had threatened people with the knife, they would have charged it. I have a great deal of respect for Mr. Rukowski, but never once have I seen him fail to charge something he could charge. And in this particular instance, felonious assault wasn't in fact charged. There was a knife present. My client did make inappropriate statements. For those reasons, I do believe that scoring 5 is appropriate. I just don't think there's enough evidence to score 15 as though he threatened the people specifically with the knife. And for those reasons, Judge, I object, and I think that the scoring should be a 5.
Very well. Before I go to Mr. Rukowski, the probation department scored this matter at 15. Your reason for this?
Yeah, on page 9 of 14 of the police report, if one of the interviews of the witnesses indicated that said that she noticed the subject had a knife on him and he proceeded to hold the knife up in the air and said, "I'm going to F you up, all up." And immediately got her grandkids into the camper. So there's that fear there, Your Honor. And also her son also stated the same statement in the same, on the same page of the police report. And that is why, Your Honor, I scored it.
All right. Mr. Rakowski, your position, sir.
Your Honor, as it relates to the charging decisions, of course, probably well aware, and that's why we said we wouldn't bring any further charges. We don't charge everything under the sun right away. If need be, because we have to proceed on, there is a felonious assault here. We chose to charge the carrying a weapon with unlawful intent because that carries a 5-year felony versus the 4-year for the felonious assault. As it relates to the weapon, as Department of Corrections had indicated, so there were various witnesses, Mr. Shapinski, who told the police that the defendant had an open knife in his right hand, was threatening to kill them. And the other witness, which department referred to, Ms. Piazzo, said that she told the police he was holding a hand or holding a knife in his hand, stating, "I'm going to F you up." Her son also witnessed the same behavior and gave a statement from the defendant. And then further on, it said that Ms. Piazzo, I believe is how you pronounce that, once the defendant had done this, she immediately got her grandkids into the camper after seeing the defendant holding a knife in his hand and threatening to F them all up. So based on that, we ask that the court agree with the sentencing and hold it at the 15 points. We believe it's appropriate under the circumstances.
Thank you. Mr. Turtles, any rebuttal argument?
Agree with you. I concede that the statement, "I'm gonna fuck you up," would cause anyone concern. But that's different than saying he used the knife in a threatening manner. I think that what's evident is after this happened, after she put her grandkids in the camper, all these same people followed Mr. Callahan around, followed Mr. Callahan throughout the entire event. And I think that's sort of indicative of the fact that he wasn't necessarily a threat with the knife. He was just threatening people. And that was what caused him the concern, was the threats he made, not necessarily a threat with a knife. So in the circumstances, Judge, I do believe fine is appropriate.
All right, thank you. The challenges to OV1 aggravated use of a weapon. The probation department scored that matter as 15 for that variable, where a firearm was pointed at or toward a victim, or the victim had a reasonable apprehension of immediate battery when threatened with a knife or other cutting or stabbing weapon. The defense response is a weapon was displayed, and they can see that. There's no question about that. The standard of proof is preponderance of the evidence. That's what the court has to consider relative to the sentencing guidelines in this matter. When certainly Mr. Turkelson makes a valid argument regarding clearly a weapons display, number one. Number two, as this event is going on throughout the park, there are individuals that are following the defendant. There's no question about that. However, there were statements provided in the police report relative to holding the weapon in the air, and I'm going to F you up, to the extent where individuals were going into campers. And that's where I think the latter part of the instruction relative to 15 is applicable. The victim had a reasonable apprehension of immediate battery when threatened with a knife or other cutting or stabbing weapon. Respectfully, the court finds on a preponderance of the evidence standard, OV1 is properly scored. Let's go next to OV3, please.
Thank you. I think this one's a little more straightforward and less factually significant. Under the circumstances, what the defendant is being sentenced for, or what the guideline that we're applying right now is for the crime of carrying a weapon with unlawful intent. And I think the facts are very, very clear that on this particular occasion, my client had a knife, as this court's already indicated, has been proven by preponderance of the evidence. He was walking around with a knife, and the officers got on scene and ordered Mr. Callahan to drop the knife. Within about 1 minute of getting on scene, my client did in fact drop the knife, and the officer, Mr. Deputy Wells, was able to retrieve that knife and make it safe, so to speak, and he had possession of that knife. However, the confrontation, so to speak, with Mr. Flory continued beyond that, for some minutes beyond that, until eventually Mr. Flory made the inappropriate decision to strike the officer one time and then went ahead and got on the ground in a prone position, was eventually taken into custody. That happened sometime, that striking of the officer happened sometime after the knife had already been seized and no longer was Mr. Floyd in a position where he was carrying a weapon with unlawful intent. He didn't have the weapon. So at that point, that crime had ceased to continue. That crime was done. And then he went ahead and made the inappropriate decision to hit the officer one time that I'm not arguing whether or not it caused injury. It did. And that being said, that would be appropriately scored under the R&O causing injury, the injury that in fact occurred. But it isn't appropriately scored as it relates to the carrying the weapon with unlawful intent, because that crime had already concluded. And the case law is very clear. Some of the various guidelines you can apply post-event conduct to the scoring. For example, OV-19 almost always is applied. But under this particular OV, there's no language that would allow this court to consider that behavior in enhancing this particular guideline up. And so I don't think that it should be scored under this particular circumstances because that injury occurred after the scoring event had taken place, Judge. Thank you.
Thank you. Response from the probation office, please.
On OV3, Your Honor.
Yes.
In regards to page 12 of 14, at the very top, the officer stated, I also took photos of Deputy Wells' injuries and the suspect's injuries. So it talked about that there was injury from the officer that took place. Also on page 7 of 14 indicates, I observed that Deputy Wells had blood around his lip area. Deputy's finger was also bleeding. So there's also injuries that indicated in that section of the report as well, Your Honor. That is why I scored the points I did.
And you scored them at 10, I believe, correct?
Pardon?
You scored them at 10, correct?
Yes, Your Honor.
Okay, thank you. Mr. Rukowski.
Your Honor, as you decide this one, Mr. Turkles and I have discussed it, and I believe that it's when you look at the strike compared to the incident with a knife, we would argue that it's one continuous event because it starts off with the narrative from Deputy Wells that when he arrived, he said, I passed a large man with approximately 300 pounds, my patrol vehicle with a knife in hand, blade out. And then there was this back and forth to try to get him to drop his knife. I screamed at him to drop the knife. After about a minute, the man dropped the knife, started to walk away. And then from there, he gave him commands. And then it goes down where eventually later in that paragraph, he says he was struck. So if the court determines that that crime has ended, Mr. Turkleson is exactly correct. And that 10 points should not be scored. And then that would take the guideline down to 14 to 29 versus the 19 to 38. However, if the court continues, believes it's one continuous event, because these things are all happening at that time, then it's properly scored.
All right, thank you. Mr. Turkles, rebuttal.
Very briefly, Judge. I think this court understands more than most that all crimes are made up of elements. And the simple fact is one of the elements of carrying a weapon with unlawful intent is you have to be carrying the weapon. And that ended when he surrendered the weapon to the officer. And then there was some time had passed, and I'm not here to say days, Judge, but certainly minutes had passed, maybe 5 minutes or so based on my recollection of the video. Crimes end and new crimes begin, Your Honor, and that's what happened here. Carrying unlawful with unlawful intent has ended, and subsequently, my client struck the officer. And those are separate events, and as a result, I believe that separate instances, which should be scored 0 in this particular instance, as opposed to 10. Again, I'm not arguing whether or not Deputy Wells was injured. He was. It just can't be scored in this particular crime.
All right, thank you. Same standard of proof applies, preponderance of the evidence relative to OV3. OV3 was scored at 10 points. Bodily injury requiring medical treatment occurred to a victim. Now, we know that occurred regarding the resisting, obstructing, causing injury. No question about that. This is being applied to the carrying a weapon with unlawful intent. And I would say probably over the last maybe 6 years, the appellate courts, Michigan Court of Appeals, and clearly the Michigan Supreme Court have looked at these sentencing guideline factors, which are to be considered. They're not mandatory. They have to be considered. And you have to look at when the crime was completed. And certainly, at least from review of the pre-sentence report and hearing the accounts of the probation officer, Once the knife was out of the situation, technically speaking, and this is under appellate law or appellate cases, that the crime at that point is completed. Now, common sense is Mr. Rakowski's argument, frankly, that this is just a sequence of events flowing through. And I agree with that. However, courts have ruled that way previously, and courts have been overturned on that as well. As a result, the crime was completed once the knife was dropped. There was a gap in time regarding the time the knife was dropped to the time that the assault or the injury occurred to the deputy. As a result, court finds that for at least purposes of OV3 on the knife charge, OV3 should be scored at 0 on granting the defendant's motion. That would reduce it to 14 to 29, as I understand it.
I would agree with that. Thank you.
Any other objections to the scoring of the guidelines?
None for the defense attorney.
All right. Anything you'd like to say on behalf of your client before the court imposes sentence, Mr. Turkleson?
There is, Your Honor. Obviously, my client stands before the court with guidelines that would give this court the opportunity to send my client to prison. And as the court's also indicated, that the guidelines are not mandatory, but in fact are, up to the judge to make discretion. They are.
So they have to be considered.
Exactly.
And I apologize for interrupting you, Mr.
Oh, not at all, Judge. And as I sit here, or as I stand here, I wonder if I'm in your shoes or if I'm in Mr. Rakowski's shoes, what's the best outcome that we can have for our community, for Deputy Wells, and for my client? And without question, I think the best outcome is that he never engaged in this kind of behavior again. That Deputy Wells never suffer the stress that goes along with trying to challenge someone the size of my client with a knife. That my client never acts in ways that makes people feel threatened, that my client doesn't do the kind of things that he did that night. And I think that is the most important thing that come out of this. And then there's also a penalty phase, a penalty portion that needs to be considered as well. And Judge, I think what stands before you is an individual who on this particular occasion made a terrible mistake, made some really poor judgments. And the poor judgments that he made were sort of the result of a lot of years of struggle. And I think I laid out my sentencing memorandum, Judge, the struggles that my client has had with opiate addiction, the death of his father and dealing with that. And to my client's credit, he's really tried to deal with the opiate addiction. He's put himself in treatment on 2 separate occasions. He's gotten away from the heroin, from the opiates. Part of his recovery, however, was the recovery that many people turn to is over-the-counter medications, or what they perceive to be medications, to make them feel better. He wasn't on Suboxone, but instead was taking Kratom, which can be mirror many of the same treatment that Suboxone mirrors in terms of it sort of becomes a replacement for the opiate. And he's using it in a way that is legal because he can buy it at a gas station. He's using it in a way that has really helped him. He's using it in a way that he had all the time. And yet on this particular occasion, when he took it, he had a completely different reaction. A reaction that is consistent with Kratom Intoxication, psychosis. As on this occasion, he thought people were trying to kill him. He thought the officer was trying to kill him. He expressed that on numerous occasions throughout the interaction with the officer. He was looking for a friend that no one had seen. He was confused. He was sweating. All the very common characteristics you see with one suffering from Kratom Intoxication. And then fast forward about a half hour after the incident, he's at the police station being interviewed by the officer. He was a completely different person at that point. He was cooperative, he was respectful, he was apologetic. He expressed to the officer, I've never had this reaction before. I thought this was a dream. I thought this was a nightmare. I didn't realize this was real. All the hallmarks of someone suffering from hallucinations due to Kratom Intoxication. And at first blush, the court might say, well, that seems convenient. And yet, that's what we saw in a time in which he couldn't have made that up and couldn't have suddenly decided, oh, I'm going to feign having this reaction to Kratom. And then just about 2 weeks ago, over my email, I get a notification from the Michigan Department of Health talking about the problem with Kratom Intoxication and talking about the fact that in 2025, saying here this took place, there was a tremendous increase in Kratom overdoses in which Kratom had become much stronger, but no one knows about it because it's not regulated by the FDA or anyone else. It's just an over-the-counter medication that people take. And clients like mine found themselves in situations where they ingest what they typically had ingested. And my client's not doing it for a party. My client's doing it because it gives them energy. It helps with the cravings from the opiates that many people feel for years after they quit drugs. That's why he's taking it. But on this occasion, he had a reaction that just wasn't expected until you step back and see what's going on. And it's Kratom manufacturers who are making it stronger for one reason, Judge, to make it more addictive and to make more money. And my client, unfortunately, suffered the consequences of that. I think that's very significant, Judge. And it's significant because this wasn't a defendant who came to that park on that occasion looking to harm anyone. He didn't come there looking to threaten anyone or abuse anyone. I suspect, Judge, if it wasn't for the Kratom, you would never have seen my client, period. But that day, he made a poor decision based on that intoxication. Now, does that justify his actions? No, Judge, I know legally it doesn't. And I recognize voluntary intoxication, even if you didn't mean to get that intoxicated, isn't a defense to a specific intent crime in Michigan, nor should it be. But what I am here to say, though, Judge, is it characterizes or colors my client's behavior much differently than the average guy who got in a fight with his wife and is willing to take on anyone who tries to stop, who's a genuine threat to the community. My client only posed a threat to the community if he was under the influence, unbeknownst to him, of this Kratom. And so how can we be assured that's not the behavior he's engaged in going forward? Because I know this court has to be concerned about that. And I think to some degree, his conduct while out on bond is indicative of that, Judge. Is indicative of the fact that he isn't any longer a threat to continue to consume that. Your Honor was very clear to him when he first got on bond. He tested positive for Kratom on a couple of occasions, and Your Honor said in no uncertain terms, no more Kratom. And that was 5 months ago, 6 months ago-ish. He hasn't tested positive since then. Your Honor recognized the need that he has for helping him deal with the stress and things along in his life. And you said he can use marijuana. And so he has used marijuana sparingly while out on bond. Hasn't used Kratom at all. Has expressed to me he's a better person for it. He's a better person, and he doesn't have a desire for the Kratom anymore. In fact, he's trying to cut down the marijuana as well. He doesn't want to rely on that either. But this is a guy who years ago was addicted to heroin and in the throes of that addiction, who got out of it, found a solution. It wasn't the greatest solution in the Kratom, and has now found a more appropriate solution. So is he going to reoffend? Judge, no one can predict the future. But what I can say is, if the past conduct on bond is any indication, he's got a real good chance. And Your Honor would hold it against him if he didn't successfully behave on bond. By the same token, I think that Your Honor should give him the benefit that if he did behave on bond, that is a good indicator of what he has to offer this court. And so the issue then becomes, what's the appropriate sentence? The guidelines call for 14 months. I would respectfully indicate to the court, I think that's excessive. And I don't, by saying I think it's excessive, I am in no way minimizing what Deputy Wells went through. And I am in no way justifying my client's behavior. He behaved atrociously on that occasion. He's lucky he didn't get shot on that occasion. I can see that, Judge. And thank God that Deputy Wells had enough foresight to see that he could handle the situation with less than lethal means. And my client appreciates that. But what does that serve in terms of society, in terms of my client's future? Because those are the two primary concerns this court has to sense. I would submit to the court 14 months for my client doesn't help society any more than a sentence of probation with a boot camp component. I would submit that sending my client to the MDOC immediately to then go into boot camp offers society no more protection than putting them on probation and requiring a boot camp component. The boot camp offers discipline, offers treatment, and requires my client to prove himself. And this court and society is no worse off if this court gives him the opportunity to prove himself. And if he fails, he goes to prison. I don't know that sending the person off the bat is justified here. In fact, I don't believe that it is, Judge. And I think that if my client had been a problem on bond, you had no choice but to send him. If my client didn't have a good job like he has, my client didn't have the family support that he does, yeah, prison may be the best place for him until he can get into the boot camp program. It's not what you have here, Judge. My client's brothers is waiting outside. His mom wanted to be here, but my client said, look, I can do this on my own. I got myself into trouble. I can handle this. And she's more than supportive. Obviously, his dad has passed. He is a guy that you could take a chance on, Judge. And if you take a chance and he screws up, you have the same power to send him to prison and even more justification. So under the circumstances, Judge, I believe that the guidelines are properly scored at 14 months. I believe it's excessive. That's not who this gentleman is. I would respectfully suggest that an order of probation with requirement for the boot camp is the more appropriate resolution for all the reasons I stated, Judge.
Thank you. Does your client wish to speak in light of the no contest plea?
He does, Judge. I think you want that.
Mr. Floor, if you wish, you may.
I do. I wanted to thank the court for giving me time to show that I can clean my act up and drop clean, not get in trouble and all that. And I also want to apologize to the community that night and the officers that I frightened that were on the scene that night. To my reaction to the Kratom, that's not me. That'll never happen again. I've been off of that since that day you told me to stop, and I did.
Thank you. Mr. Rutkowski, anything on behalf of the people, this is a victim's rights case, and please, this, or whomever, please silence your phone. Mr. Rutkowski.
Your Honor, Deputy Wells and myself have talked multiple times on this case. I knew he wanted to be here at the last sentencing. I'm not sure where he was today, but we've had conversations about this circumstance and how it's affected him. I would point out to the court that I understand what Mr. Tripleson is saying, and I would equate it very similar to the use of alcohol, which you can use legally, yet if you get behind the wheel and you drive and you injure somebody, it's no excuse. And the same thing here. Even though it might have been legal to buy, he bought this stuff, he used it, and put a lot of people in fear at the campground to the point where the police were called and Deputy Wells arrived, and Deputy Wells is trying to deal with Mr. Flory, and when he's dealing with him, he's not getting, the compliance with the defendant. And in turn, the defendant had punched him, bloodied his lip. And so from that struggle, and he had to be tased by, I believe it was Sergeant Woodward when he got there. We looked at the guidelines, and in the recommendations, I see the recommendations, although the guidelines aren't the same now, they were 19 to 5 years on count one and 19 to 4 years. They're different grids. So I would look at the idea that the recommendation made for at least count 3, which was the RO causing injury, took that into account, that it was not at the low end of the guidelines, but was somewhere in the middle of the guidelines. And we would ask to continue with that one. I mean, we know the guidelines are now 14 to 29, but we're asking the court to consider that. As far as the SAI, court's practice has been, and we would agree that it would be in this case, that if the Department of Corrections is where Mr. Flory goes, that the Department of Corrections will score him and determine whether or not SAI is appropriate. They can reach out to the court and ask for that permission. So otherwise, we'd ask you to adopt the recommendations as set forth.
Compelling arguments on both sides, clearly, and the court has to consider that. Before I go into the sentence here, the reason that I was involved with Mr. Flory regarding the Kratom was we were in a state of flux regarding our district judge, probate judge retiring, and I had to cover the courts until our new judge was selected by the governor. So that's how I got to know Mr. Flory initially, by being a part of the district court process. And at that time, there were conversations, and always the conversations are with both attorneys, where we have discussions regarding how the case is proceeding, and there was an issue regarding Kratom. And this reminds me, this substance reminds me back in the day of the old bath salts that used to be out there years ago. And you could go to the north end of town, pick up the bath salts, and we remember how that affected not only the state and the country, but this county as well. Mr. Rakowski has oodles of cases relative to those types of matters involving bath salts. And here, this is to the court, frankly, a new bath salt is what this is. Kratom, you can go right now in Huron County and purchase it. And it amazes me that substances like this are available, but they are available. They're not regulated in any way, shape, or form currently. Maybe they will, but it's a substitute for other substances with individuals who have substance use disorder. Mr. Flory has substance use disorder. There's no question about that. And on the night in question, if you were in the park at the time, just merely observing what was going on, I couldn't imagine how you'd feel. It was that crazy, that it was that out of control overall when you're at a campground, merely enjoying your time. And next thing you know, there's a fracas going on outside. Eventually, police arrive, knife is gone, but the knife was out earlier. And tased, assault upon a police officer. I mean, it was not a pretty sight, clearly. And so the court obviously has to address that and the behaviors of the defendant. But clearly he was under the influence of this, I'll call it a poison, it's what it is. That's truly what it is. The poison led him to do some really dumb things, frankly. And I mean no disrespect, but that's exactly what happened. And we have an individual who is a high school graduate, gainfully employed, no prior felony record at all. None. He has 4 misdemeanors, 39 years of age at the time, but no prior felonies. And so at first blush, when you look at this, hey, wait a second. Obviously, not a wise decision to substitute, well, I guess it would be wiser than using heroin or other substances, kratom, but that was the driving force that particular night. Now, Mr. Turkelson is absolutely correct. Voluntary intoxication is not an excuse, and they concede that. However, by conceding it, they also understand, hey, look, you have to look at the entire behavior. You have to look at the entire scenario here, and the court is looking at that. That's one side of the story. Here's the other side of the story. Individuals going back in their campers in fear. Police officers getting injured. Tasers being utilized. Knives, not pointed, knives displayed. And frankly speaking, when you look at that behavior as well, one asks oneself just simply, how or why would you act that way? You're here enjoying your time with family or friends, and all of a sudden, frankly, for lack of a better phrase, all hell breaks loose. That's what happened here. And the intoxication is not an excuse or justification for it. It explains behavior, but it doesn't necessarily justify it. And here's another example of what the court has to at least consider. That is the sentencing guidelines. The court is required to at least consider the guidelines. Back in the day, they were mandatory. And absent substantial and compelling reasons to depart, you had to be within the guideline range. Now, we have case law that has just come out last week that an in guideline range sentence was remanded back to the trial court. That even though it was within the guideline range, it wasn't appropriate. Matter is going to be remanded back to the trial court in another county, and we're going to start the process all over again. So I guess when you say discretionary relative to guideline range, I guess it's clearly discretionary because, again, the new case law that's coming out is a little concerning. Now, I don't care if it's Huron County, Genesee County, Lapeer County, it doesn't matter. You have to conform your behaviors to societal norms. That's just the bottom line. And this court has been extremely consistent, at least I hope it has, relative to considering the guideline range. At first blush, I couldn't imagine if I saw the video of this. It wouldn't have been pretty. And the court could sentence to 29 months. 29 months to 5 years, at least on count 1, 29 to 4 years on count 2. But the court is balancing all that because when you consider the guidelines, you consider the terrible decisions made by the defendant, but the changes that have been happening, there's been some positivity to warrant at one point, not 29, not the midpoint, but what the court finds to be, and this is just remaining on consistency, number one, and fairness to any individual that comes before this court, is some sort of consistency that when you understand you come before this court, this is likely what's going to happen. And when I consider all that, and I consider the defendant's behaviors since then, and the guideline range now is not 19, it's 14. The court could depart lower and give 12 months of counting. Sure, it could. But under the circumstances here and the behaviors of the defendant, which I find to be not necessarily normal, however, but based upon the use of the substance, it will be the sentence of this court that the defendant be committed to the Michigan Corrections Commission, placed in the commission's custody to the low end of the guidelines, 14 months, 5 years credit for 2 days served. That's just to count 1, count 2. In count 1, restitution to Deputy Wells in the amount of $10, $10 to the Sheriff's Department. Wage assignment to pay that if he's employed and misses 2 regularly scheduled payments. Crime victims assessment of $130, DNA testing of $60, state cost of $68. Count 3, the RNO causing injury. Again, 14 months to 4 years, credit for 2 days served. $68 in state costs will be ordered. That also includes count 4 and 5. Count 6, the indecent exposure. 365 days county jail, credit for 2 days previously served. $186 in state costs will be ordered as well. Regarding the SAI program, the court can consider that, but not today. I'm staying consistent as I have in the past. However, it's my duty to inform the defendant he has right to seek leave to appeal. If he's financially able to provide counsel of his own choice, the court will assign counsel for the public expense. He's conditioned to receive the questionnaire, form requesting the assistance of counsel, both of which must be executed under oath and filed with the court reports within 42 days. Is Evelyn, what
Your
did I-
Honor, count 4, count 5, and count 6 are all 12 months jail, correct?
What are the guidelines? Because I said 14. Oh, that's right, it wouldn't be 4 years. I apologize. I stand corrected. 4, 5, and 6, 365 days in the county jail, credit for 2 days, sir.
Thank you, Your Honor.
My mistake.
Okay, so count 1 is 14 months to 5 years.
2, 14.
4, okay.
And all remaining are
And then count 3 is 14. And then 4, 5, and 6.
or you'd like to use it.
Judge, can we approach it briefly?
Yes. White noise off. We're gonna have a change on count
Well,
6.
oh, I know. Some counts. That we can't-
1, 3. That is correct.
Okay, so
There's no
we've got an
count.
extra. Okay. Got an extra one.
All right, count 6. This was part of the plea agreement. And that is a delay of sentence relative to count 6.
That's correct.
That was placed on the record beforehand, and it was reflected here in the report, but I do recall that. So relative to count 6, defendant, and it's a delay of sentence under the delay of sentence statute.
Correct.
So we would do a review of that next year. Delay of sentence relative to count 6. Obviously, there's no jail time imposed for a delay of sentence. This is not technically a sentence, but the state cost would still apply.
Thank you.
And we'll get a date.
March 29th.
March 29, 2027.
Judge, could my client have an opportunity to turn himself in, or is this court to find that it had be remanded at this point?
He's remanded to custody of the sheriff. Off the record.
Okay, I got to admit, friends, that the final sentencing there was a little bit confusing. I think it's concurrent, but it might have been consecutive. I'm not sure, and they were trying to correct stuff themselves there at the end. So confusing. Other than I think we're all in agreement that none of us particularly liked that defendant. That seemed to be obvious in the chat. I did want to bring up real quick, since there was a couple of people, I believe, in the chat who were questioning kratom and what that is. Kratom is a tropical evergreen tree native to Southeast Asia. Its leaves have been traditionally used for hundreds of years for their stimulant and opioid-like effects. In the U.S., it's often sold in powder, capsule, or liquid extract form, marked as a natural supplement for energy, pain relief, anxiety, and to manage opioid withdrawal symptoms. So we know a little bit about kratom here in the bunker, not because we've ever used it, but because it was actually presented to Beth as an option to deal with her chronic migraines kind of off the books. Dr. Brain, as we call her neurologist, has told us that he has some patients who have responded well to it to deal with their migraines, but he also issued the warning that there's no control over it whatsoever. So the dosing of it, the potency of it is just all over the board, and you don't really know what you're going to get. So from that standpoint, it can be dangerous as well. So we've never chosen to go there because of the fact that it's hard to find kratom that's actually what it's marked. So the quality is just not there. So hey, thanks for watching this clip from TCF Live. If you enjoyed it, please leave a comment, like, and subscribe if you haven't already. And you can join us weekdays live, 9 a.m. Eastern, 6 a.m. Pacific, right here on this channel.